Great job at the women's event.
Thank you.
This afternoon. Let's take up, Chairman Shukaku has a bill, which is 5698. This act would, Leader Shukaku, would eliminate the requirement of identifying the name or names of the author of a circular, flyer, or poster designed to injure or defeat any candidate for election in public office. We have Stephen Brown from the ACLU and Bob Rapoza from the Board of Elections here to testify. Mr. Brown, whenever you're ready.
Thank you again, Chairman, members of the committee. I'm here to express the ACLU's support for this legislation. I just want to give a very brief history of it and why we think it's important that you pass a bill that's simply repealing a statute. This law is unconstitutional. There's a 1995 United States Supreme Court case that ruled unconstitutional a virtually identical Ohio statute. However, Rhode Island continued to enforce this law. In fact, a few years ago, after an individual was arrested, charged with violating this law, we decided that the charge was ultimately dismissed on the grounds that the prosecutor admitted that they could not go ahead with the charge because of the U.S. Supreme Court decision. We then learned from somebody else who had expressed an interest in distributing an anonymous flyer that the town would continue to enforce this law as long as it was on the books. We therefore filed a federal lawsuit against the town, and a judge ruled that the statute was unconstitutional, as had been argued for many years since that United States Supreme Court decision came down. But, as I said, a town continued to enforce it, notwithstanding advice that it was unconstitutional. So we think to avoid any further illegal arrests or improper activity by government, the best thing to do would be to just repeal the statute, keep it off the books, so no erring officer can look in the general laws and think that they have a right to enforce this law. So for those reasons, I hope you'll give the bill favorable consideration this year. Thank you.
Thank you, Mr. Brown. Representative Corvese.
Well, let's have a talk about this. I understand, because of the Supreme Court decision, that this is unconstitutional. I also understand that at least since November of 2016, the populace's ideas of what laws should be enforced and what shouldn't seems to be very fluid nowadays. We even have elected officials proclaiming what laws they should support and what they shouldn't, and how they're not going to support laws. I'm disappointed that the Supreme Court would make such a decision, because while I understand that there's a freedom of speech aspect here, and I'm not a lawyer, and I don't pretend to be, what recourse does an individual have to advertisements, circulars, flyers that are plainly defamable but have no author? So they hide behind the law. What recourse do they have? So I can understand why the town in that particular case stood up for the rights of the little guy. Because obviously the Supreme Court didn't. And obviously other people aren't. So I guess I have to ask you, since we're going to take this away, what can we put in its place so that those individuals who are wrongfully defamed can achieve justice?
Well, I don't think you're taking anything away by following the First Amendment to the Constitution. I would urge you to remember that the notion of anonymous leafleting and political discourse has a very long and favored history in this country. The Federalist Papers are probably the best example of that, written anonymously.
I live in North Providence, so I know all about that stuff. Okay?
Well,
but I'm not saying I agree, but I don't agree with it.
I understand, and what I'm saying is the United States Supreme Court ruled a similar statute unconstitutional over 20 years ago. A federal district court ruled this particular statute unconstitutional 2 years ago. Why would we want this to stay on the books and let a police officer unlawfully arrest somebody who's engaged in activity that the Supreme Court has said is constitutional?
So we may be forced to take off a law off the books that's unconstitutional. What do we put in its place to achieve justice?
I don't think there's anything that needs to be put in its place. I think anonymous political pamphleteering, as I said, has a long history.
That's a truncated response and doesn't answer the question.
Let's bounce over to Representative Filippi.
Thank you. And I'm concerned about comparing the Federalist Papers to anonymous defamatory mailings. Those weren't directed at any individual. They were directing at the 13 states to enact the proposed Constitution. Don't we have a lot of laws in our books that the Supreme Court indirectly has ruled are unconstitutional?
Yes.
We do.
Yes.
And I think many of those we haven't repealed in the hope that maybe the Supreme Court would change its jurisprudence. And in this case, if we kept this on the books and the Supreme Court changed its jurisprudence, this law would again be applicable. But I guess my question is more, if someone right now, while the Supreme Court has said that this law is unconstitutional, is arrested unlawfully, don't they have a cause of action against the municipality for unlawful arrest?
Yes, they do. And if it's the body's position that it's okay to arrest people unlawfully and let them sue the city or town for damages that the taxpayers have to pay for, which is what happened in the 2014 or 15 case that we filed, I guess that is one response. I'm not sure it's the most appropriate response.
I don't think this body is encouraging unlawful arrest. I would vote against repealing this in the hope that the Supreme Court would change the way it looks at the First Amendment, and at that point this dormant statute would come back to life. Thank you.
Representative Knight.
I just have two questions, and one is just a background. I'm just curious. When people who do a paid advertisement of some kind have to, is it correct to say that they have to identify who the advertisement is paid for? Is that a different law?
Depending on so there are campaign finance laws, as you know, that do require reporting under certain circumstances. What this is aimed at is the Supreme Court case, the case that we handled, is on behalf of people who are, handing out flyers on a corner. We're not talking about people spending hundreds, thousands of dollars with political advertisements or things of that sort. And the court said, in this context, there's a very important First Amendment right to protect in terms of anonymous political speech, and therefore it's appropriate to have that sort of leeway for those types of activities, as opposed to the types that they have upheld in the campaign finance context.
Okay, great. Thank you. Second question, just in terms of the danger, I'm going to ask you a question regarding the dangers of keeping clearly unconstitutional laws on the books. And I'll preface this by saying for the folks in the room that the ACLU occasionally will go to court on behalf of a plaintiff who's been wrongly arrested or held for violation of their civil rights. And in a case where, my question for you is that in a case where the claim of a wrongful arrest is upheld, historically or to your knowledge, what is the financial hit to the town that loses that court case?
It really depends on the type of claim it is. I mean, first, to the extent it's a civil rights violation, which things like this would be, the government agency is responsible for paying the plaintiff's attorney's fees. They are entitled to that under federal law. And then if the person has also sought damages for the violation of their rights, the government agency is on hook for that. The amount of the damages, which can be compensatory or punitive, would obviously depend on exactly what the harm was. But certainly, I would think that an arrest, resulting in detention, even a short detention in jail overnight, based on a statute like this, that had been declared unconstitutional would certainly warrant some significant punitive damages.
And sometimes the attorney's fees can run into the tens of thousands of dollars. Is that correct?
Yes.
So when we have an unconstitutional law, clearly unconstitutional law on the books, but the police officer, for whatever reason, attempts to enforce the law, either at the direction of his chief or the town, or of that officer's own accord, they're not going to have the qualified immunity that they typically would because it's clearly unconstitutional, and it might cost the city or town tens of thousands of dollars. It seems like that's a good argument for having our laws that are on the books accurately reflect the current state of constitutional law. Would you agree?
Yes, I would. And of course, the other point to make is, you can, if the Supreme Court were to suddenly, I believe this was like a 9-0 or 8-1 decision. And don't hold me on that, but it was not a close decision. If the Supreme Court were to ever reverse itself, this public body clearly has the right to come back and pass the law again.
Briefly, Chairman.
Go ahead, Representative.
Is the case you're talking about in the city of Providence the Riley case?
No.
It was in Smithfield, I believe.
Yes,
Representative
it was
Flippy.
Smithfield.
Let me hop in now. Mr. Brown, I recall defending this bill on the floor maybe as many as 3 times now. In other words, this committee keeps passing this, the House keeps passing this, and it doesn't become law. Do I have that correct?
It has come out of committee at least once, maybe twice.
Yeah,
Yes.
I remember defending it probably at least twice.
Yeah.
I think then Representative Trillo famously said that we pass unconstitutional bills all the time.
Yes.
You had to be there. It's not in context. It was rather funny when he said it. But this is a bill that we've passed that the House has passed in the past, correct?
Yes.
Yeah. Any further questions from Mr. Brown? Thank you. Bob?
Thank you, Mr. Chairman, members of the committee. Bob Rapoza from the Board of Elections. This bill was introduced at the request of the board, and it was requested to be introduced according to the lines of Mr. Brown's testimony that it was a Supreme Court ruling back in 1995. Basically, again, this has been requested by the board, and I have nothing else to say because I feel Mr. Brown covered this very well. It was introduced along with our attorney. He could not be here tonight.
Thank you. Any questions for Bob? Bob, stay right there because we're going to get back to you on the next bill. That will conclude testimony on House Bill 5698 by Leader Shukaku. We did receive written testimony in support of that bill from the ACLU.